Scott, that was excellent, and I completely agree, and I'll add my thoughts here in a bit. Senator Scott, who South Carolina plays Saturday, you're welcome today, not so much Saturday. Yeah. Justice Barbara Lagoon and Justice Robert Luck are nominees for the 11th Circuit, and Senator Scott, the floor is yours.
Thank you, Chairman Graham, Ranking Member Feinstein, and members of the committee. It is my great pleasure to introduce two outstanding Florida nominees to you today, Justice Barbara Logoa and Justice Robert Luck. Justice Barbara Logoa was born in Miami and raised in nearby Hialeah, Florida. She earned her undergraduate degree from Florida International University and went on to graduate from Columbia Law School. After law school, Justice Logoa returned to Florida and spent 11 years in private practice before joining the Office of the U.S. Attorney for the Southern District of Florida in 2003. In 2006, she was appointed to Florida's 3rd District Court of Appeal by then-Governor Jeb Bush and went on to become the Chief Judge of the Appellate Court. In January of this year, she was appointed to the Florida Supreme Court, and she is the first Cuban-American woman to serve on that court. Mr. Chairman, both of these nominees have excellent records of service and a deep and abiding respect for the rule of law. Our courts need judges who respect the separate rules of our 3 branches of government. We need judges who will apply and follow the law as written and who will not legislate from the bench. I am confident that Justice Logoa and Justice Luck will honorably and faithfully serve the 11th Circuit for many years to come. I am proud to introduce them to you today, and I fully support their nominations before this committee. Thank you.
And we'll have the first panel. Please come forward. Would you raise your right hand, please? Do you solemnly swear that testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God? All right. Judge Logoa? Is it Logoa?
It's Logoa, Senator.
Okay.
Thank you. Good morning. Thank you, Chairman Graham and Ranking Member Feinstein, for scheduling and holding this hearing to consider my nomination. I am deeply humbled to be here today. First and foremost, I would like to thank President Donald Trump for nominating me. It is a privilege and an honor to be considered for a seat on the United States Court of Appeals for the 11th Circuit. I want to thank Senator Scott for his kind and gracious remarks and Senator Rubio for his support of my nomination. To the rest of the members of this committee and the full Senate, I thank you in advance for your consideration of my nomination. I know my time is limited, but I would like to briefly introduce and thank my family and friends who are here today to support me. Sitting behind me are my husband, Paul Huck Jr., and our 3 daughters, our twins, Claudia and Eloise, and our younger daughter, Camilla. Paul and I have been married 23 years. He's a practicing attorney, and I would most certainly not be here today without his love and support and his ability to roll with the drama of a house full with 2 teenagers and 1 teenager to be. Our daughters, Claudia and Eloise, are in the 8th grade. Both are in the National Junior Honor Society. Claudia runs on the cross-country team, and Eloise plays volleyball. Camilla is in 7th grade, and like her sisters, she's an amazing student and a star athlete in volleyball. Life with my 3 daughters is never boring, and I am grateful every day for the opportunity to be their mother. I am particularly proud that they are able to be here to witness our Constitution in action, as this body exercises its constitutional responsibility of advice and consent. Also here are my in-laws, Paul and Donna Huck. My father-in-law has served this country with distinction, humility, and integrity as a United States District Court judge. In fact, Chairman Grassi at the time was the one who presided over his hearing. For over the last 13 years that I have been an appellate judge and now a justice on the Supreme Court of Florida, I have looked to my father-in-law as a model of what a judge should be. I also want to thank my dear friends who were able to join us here today, many of whom flew from Miami. Annie Cadre, godmother to our daughters, and her daughter Carolina. Annie traveled with our girls yesterday so that they would only miss 1 day of school. I want to thank her for doing that. And today is also Annie's birthday, so happy birthday, my dear friend. Lily Ann Sanchez, a dear friend and also another godmother, is present here today. Lily's son Andres is in his 3rd year at the Naval Academy, and we are so proud of him and his commitment to serve this great country. Thank you also to other friends who are present here today and so many others who are watching from home. Finally, I want to introduce to the committee two people who could not travel here today. My parents, Antonio and Araceli Logoa. They're both in their 80s, but they are streaming this live today. In 1966, they boarded one of the Freedom flights from Havana to Miami. That was the last time they saw the country they were born in. But they did it to seek the freedoms that this great country offers. I owe my parents everything. They left Cuba without anything but their education, their strong work ethic, and their desire to succeed. And these are the values that they have instilled in me. As a judge, I owe to them my deep belief in the fidelity to the rule of law, that the law must be applied in an impartial and consistent manner to the parties who come before us, without regard to status, means, or a judge's personal preference. Unlike the country my parents fled, we are a nation of laws, not of men. Thank you again, Mr. Chairman and Ranking Member Feinstein, for scheduling this hearing. I look forward to answering the committee's questions this morning. Thank you.
Thank you. Judge Lagoa, tell me the role that you have today in Florida law in terms of reviewing cases that originate at the equivalent of the district court level. What do you look for to overturn a decision, and how would you apply that to the 11th Circuit if you were chosen to serve there?
Thank you, Senator, for that question. The first thing, obviously, that I look for is every case is different, Senator, and my judicial philosophy is I apply the rule of law to the facts of the case. So the first thing is what is the kind of case? Is it a constitutional case? Is it a statutory case? So the first thing is, if it's a statute, I look to the text of the statute in order to determine whether or not the text of the statute is unambiguous. If it's unambiguous, then I'll apply the statute as written. If it's a contract case, we're going to look to the contract first. But generally, I make the decisions, judicial decisions, based on the rule of law and the application of the law to the facts.
Thank you. As both of you understand, at the circuit court, you're bound by Supreme Court precedent. Do you all understand that?
Yes, I do, Senator.
And if somebody is challenging precedent, you will give them their day in court and listen to their argument?
Yes, Senator.
Okay.
Absolutely, Senator, as I've done with every single case that has appeared before me in the last 6 years.
Okay. Thank you very much. Senator Feinstein.
Thanks, Mr. Chairman. I'd like to begin with Justice Logoa. Madam Justice, in 2016, while on the 3rd District Court of Appeals, you wrote or joined opinions in several cases overturning damages awarded by juries to employees alleging retaliation and discrimination by their employers. In one case, an employee of Caterpillar, Rudolph Amaya, alleged that he was fired in retaliation for filing a workers' comp claim. A jury ruled in his favor and granted him over $500,000 in damages. On appeal, you voted to reverse the jury's decision and said that he was not entitled to any damages for the retaliatory firing. Would you comment, please?
Yes, thank you, Senator. Obviously, workers' compensation is important, and workers' rights are also important. But my job, Senator, is to follow the law and to apply the law to the facts of the case. And in that case, the law required the result that was reached by the panel decision.
Would you explain how so?
Because in that case, the damages, the individual in that case did not have the ability to perform work at the time. And so therefore, under the law that exists in Florida, he is not entitled and was not entitled to be compensated for his lost wages if he was unable to work at all. He was compensated in the workers' compensation scheme that the state of Florida has. Now, Senator, again, I decide all cases based on the law, the applicable law, and the application of the law to the facts in that case. There's another case I had where the employer had denied workers' compensation to the employee in the workers' compensation scheme. And as a result of that, the employee then filed a negligence claim against the employer for the damages that he suffered as a result of the injury suffered at work. And in that case, I personally wrote that opinion. It's called Coastal Masonry. And in that case, I allowed and I affirmed the trial court's entry allowing the employee to proceed against the employer in a negligence action because the employer was not allowed to have a shield and a short. He could not say, it's not a workers' comp case, and then be able to assert workers' compensation immunity. So again, Senator, I review the case. It's irrelevant to me who the litigant is. It's only based on what the law and the applicable law is to the facts of the case.
Thank you.
Thank you.
Memory too.
Thank you. Thank you. I want to ask about statutory interpretation and the role of legislative history. What do you see as the appropriate role of legislative history when interpreting statute? And that would be to both of you. Either one can start.
Well, for me, Senator, the text of the statute is the applicable law. That is, to me, what the law is. And from my 13 years as an appellate judge, I have found most statutes to be unambiguous. And I have not ever had to resort to looking at legislative history. Legislative history can be confirmatory, as the United States Supreme Court has written on, but from my perspective, legislative history is not something that I look at.
I'd like to have you think in terms of a continuum from judicial activism at one end and judicial restraint at the other, and tell me where you fall. Start with you, Ms. Logoa.
Apologize. To me, the term judicial activism means that a judge is reaching a result based on the judge's own personal preference, and that is antithetical to what I believe a judge should be. Your role as a judge is to apply the law, the rule of law, to the facts before you. It is not to make laws or to legislate from the bench. That is not the role of the judiciary. And Senator, as I indicated in my opening, my family fled from a totalitarian regime where the whim of a dictator could determine what the law was. And to me, the application of the rule of law, the neutral application of the law, regardless of economic status, means, race, gender, is very, very important. And the text of the statute or the law is what controls.
And my last question would deal with a subject that most often is discussed when we have Supreme Court nominees before us, but since you're appellate, it might apply logically to you in some instances as well. And that is it ever appropriate for judges to rely on foreign law in determining the meaning of a constitution or an interpretation of statute?
Senator, from my perspective, the answer is no. It's not appropriate to look to foreign law in order to interpret either a statute or a provision of the U.S. Constitution or a law passed by Congress or even a law passed by the Florida legislature. The only method or the only reason I would ever look to foreign law is if there is a contract before me where the parties have agreed to foreign law being the law that controls the case.
Okay.
Let me ask you, I respect your desire to avoid any comment on a case that may be coming before your court, but just as a matter of your view of avoiding the kind of injuries and death that result from gun violence, suicides, domestic violence, mass shootings, what's your impression as to what the experience in Florida has been? Let me ask both of you a question that I ask all nominees. Do you think Brown versus Board of Education was correctly decided? Judge Logoa?
Senator, I believe that normally, as you know, it's not appropriate to grade a Supreme Court decision, whether it's correctly or incorrectly decided, but I do believe and I feel comfortable because Brown has a historical significance in correcting the racial injustice of Plessy v. Ferguson, that I believe that Brown v. Board was correctly decided because it did correct a grave injustice of racial inequality.
I assume you give the same answer, Judge Love.
It's hard to improve on that, Senator.
Well, I've noticed you said that 3 times about Judge Lagoa's statements, and justifiably so.
Justice Logoa has been my senior colleague for years now, and it's always a good bet to say she did a good job.
Judge Logoa, you have a profoundly impressive story. It's your parents' story and your story, and I know they must be very proud of you, as your whole family is. I'm particularly happy with the fact that very unusually a Latino or Hispanic nominee has come before this panel. The fact of the matter is that only 6.6% of federal judges are of Latino or Hispanic heritage descent. And so in a country where more than 18% of our population is Latino and Hispanic, we should be doing more to attract nominees with that qualification. We should also be doing more in terms of African Americans, who make up 12.5% of the U.S. population, but only 10% of Article III judges. 80% of all federal judges are white, 73% are male. Women make up only 27% of sitting judges, despite there being 51% of the population. These statistics are very well known, very long established, and really regrettable and unfortunate about our federal judiciary. So I welcome particularly your nomination and your qualifications to the federal bench, and wish you well. Thank you.
Thank you, Senator.
Chairman.
Well said, Senator Blumenthal. Senator Lee.
Justice Lagoa, so you and Justice Luck both serve on the Florida Supreme Court currently. That's a 7-member court, is that correct?
Yes, it is,
And
Senator.
you sit as a body rather than in separate 3-member panels
Yes.
within that court. If you're both confirmed, you'll both be serving on the U.S. Court of Appeals for the 11th Circuit, which typically sits in 3-judge panels, randomly selected from among and between them. You'll be bound to follow U.S. Supreme Court precedent, and where it exists, you'll also follow 11th Circuit precedent. Under some circumstances, you'll be in a position to vote on deciding whether the entire 11th Circuit should consider a matter en banc, so as to review precedent. What are the kinds of circumstances that might guide your determination on whether to support review in such case?
Thank you, Senator, for that question. But you know that Justice Luck and I also sat together at the 3rd District Court of Appeal.
It's fantastic.
He's been following me around.
Yeah. Well, hopefully.
Yeah, he's getting away with murder today. All he's saying, what she said.
Yeah. Perhaps we should call each of you as witnesses on each other's nomination.
Senator, obviously at the 11th Circuit, just as in the 3rd District Court of Appeal, we're bound by the rule of en banc. And in the 11th Circuit, the first thing that I have to look for is exceptional circumstances, and that's one of the bases for deciding whether to take a case en banc. The case has to be of exceptional circumstance.
Thank you. Justice Lagoa, do you ever issue a ruling that you disagree with or that you find difficult to accept?
Yes, I do.
You struggle with them from time to time?
I struggle, but my job as a jurist and a judge is not to put my own policy preference or my own personal preference over the law. The law comes before everything.
So it's not troubling to you that some decisions are troubling. It's reassuring. The fact that you sometimes disagree with your rulings is healthy.
Well, I think Justice Scalia and Justice Gorsuch have a saying, which is, if you're a judge and you agree with every single decision that you've ever written, then you're not doing your job as a judge. Because there are times when what you personally think would be the right thing to do is not what the law calls for.
Well said. Thank you, Mr. Chairman. Thanks to both of you.
Thank you. Senator Hawley.
Thank you, Mr. Chairman, and thanks to both of you for being here. Congratulations on your nomination. And thank you for your fine record of public service in your home state. And thank you for being willing to do this job. Both of you are currently serving on an appellate court as justices on the Florida Supreme Court, of course, so you have a good idea of what you would be getting into in this next job. So let me just ask you both, how do you think your experience on the Florida Supreme Court has prepared you to join the federal bench? And what, if anything, do you think might be different about being on a federal court? Well, thank you. Go ahead, Justice.
Senator Hawley, I don't have much more to add to what Justice Luck has articulated so well, but I do believe that the job that we also had on the 3rd District Court of Appeal, which was the intermediate state court that both Justice Luck and I had and held before, really has also given us a great experience in terms of what we can expect if we were so fortunate to be confirmed to the 11th Circuit Court of Appeals. Because in that one, obviously, we sat in panels of 3. We had, in the 12 years that I was there, I handled over 12,000 appeals. So it's a very large volume of cases because the jurisdiction is not as limited as in the Florida Supreme Court.
Thank you. Let me ask you this. Can you tell us about a case either that you've seen and handled at the Florida Supreme Court or during your time on the lower state court that you believe exemplifies your own judicial philosophy? I'll ask both of you, but go ahead, Justice Logoa.
Well, Senator Hawley, I've written over 400 opinions.
Just a few.
That's kind of hard. It's like choosing your child. I love them all, okay, just so it's clear. But I think if there is a Justice Logoa or a Judge Logoa opinion, the first thing is my opinions, I hope, are well-written and clear, and either a litigant or a lawyer can understand it very well. I try to give procedural history and factual background so that when a trial lawyer has to use a case, they can actually talk to the trial court judge about what the facts of this case are and why it's applicable, or you can distinguish the case if you need to distinguish the case. But I think a case that would be instructive would be a case that I wrote called Salgado, which dealt with a statutory construction interpretation case, and that sort of is my approach to statutory construction.
Thank you. Thank you again to both of you for being here. Congratulations on your nomination. Thank you, Mr. Chairman.
Senator
Thank you.
Cruz, we're going to have a stack votes at 11. We're just going to push through and try to get as much done as we can. Senator Cruz.
Thank you, Mr. Chairman. Congratulations to both of the nominees. Thank you for your service. Let me start by asking each of you to describe your judicial philosophy.
Senator, my judicial philosophy is straightforward, which is I apply the law, the rule of law, to the applicable facts in the case.
How would you define a judicial activist?
Senator, for me, the definition of a judicial activist is a judge who rules based on their own policy preference or their personal preference, regardless of what the law calls for.
In statutory interpretation, in your view, what is the relevance of legislative history?
Senator, I've been an appellate judge for over 13 years now, and I've never resorted to legislative history. The first thing that I do, and frankly, I learned this when I was a first-year associate, which is I start with the text of the statute, and I go from there. But if the text of the statute is unambiguous, the analysis ends there. Obviously, you have to look to see if there's binding precedent that has already applied that statute or that particular rule, but that is how I analyze a case.
Shifting to constitutional adjudication, in your judgment, what is the role and importance of originalism in constitutional adjudication?
Senator, originalism is important in adjudicating a constitutional provision because I think it is important to, when you're looking at the Constitution, to see what the original public meaning or the understanding of that particular phrase meant or the particular word, and that is important. And you can see the analysis in some of the cases that are from the United States Supreme Court that deal with The last one was the one that dealt with a right to a jury trial or a determination on the Fourth Amendment, what that means at the time of a ratification on the Constitution.
So let me play devil's advocate for a moment. Why should we today be bound by understandings of people who've been dead for 2 centuries?
Senator, if we are not bound by what the Constitution means, and it is ever changing, then we're no different than the country that my parents fled from, which is Cuba. Because Cuba has a Constitution and a Bill of Rights, and it means nothing, because there's no one to hold it and to say this is what the definition of this Constitution means, if it is always ever changing. The principles that were articulated in the Constitution at the time of ratification have a meaning. That meaning is constant. What changes is the application of the meaning to new things like new technologies, in the Fourth Amendment context, for example.
Well, Justice Lagoa, let me say, to paraphrase Jerry Maguire, you had me at, this is not Cuba.
You had me at hello. So thank you both. I think that's it for this panel. Next. Thank you both. Well done. Congratulations.